Hello everyone, this is Anne with iPNOTE. This is the second part of our discussion on Brazilian IP with Luis from Venturini IP. Today we will delve deeper into special programs for patents in Brazil, exploring some pitfalls and getting special recommendations from Luis for startups. Luis, previously we discussed the Green Fast Track program for patents connected with alternative energy, agriculture, etc. And are there any other requirements to get the Green Fast Track, or is only requirement that the patent should be connected with a specific field like agriculture?
Technology must be related to alternative energies, transportation, energy conservation, agriculture, waste management. But we also have other programs that are based on not on the technology itself, but also depending on the situation of the applicant. So if it's an individual that is filing a patent application in Brazil, depending on the age of this individual, you can request the acceleration of the patent examination, depending on the structure of the legal entity. If it's a small company, small size business, if it's a startup, if it's a university, you can request a fast track examination program related to inventions developed by startups, patent applications filed by universities. So you have specific programs for the applicants. You also have programs depending on the situation. So what I mean by that is, for example, if the technology is already available on the market, you can provide some evidence of that the technology is available on the market, and the Brazilian PTO will accelerate your examination. The same thing happens if a third party is accused of infringement, if it has been reproduced. If the technology covered by the patent application is being reproduced by third parties without authorization of the patent owner, then you can also ask for fast track examination program related to that specific situation. So you have some, as I mentioned, the cooperation agreements also with other offices. So the patent prosecution highway is one. We also have the Brazilian priority program. So those are for patent families whose protection was initially requested in Brazil. So and in relation to the technology, so we have this green patents program, but we also have one for anything related to the treatment of specific diseases. I don't know if it's still in force, but we have one for the coronavirus treatment also. So anything developed and related to the treatment of specific diseases or the treatment of coronavirus, then you would be able to request fast track examination program.
Wow, quite many ways how to enter the Brazilian market. Okay, and have you ever encountered cases where an applicant would save more funds if they came to you first rather than trying to figure out the details themselves?
Yes, we have already encountered a few cases like that. So where an applicant would have saved more money, but especially more time if they had first looked for professional help. So for instance, Brazilian universities are among the top patent applicants in Brazil. So they do have innovation agencies and tech transfer offices that help their researchers to draft, to file patents and license them. But sometimes in a few cases, researchers may decide to no longer rely on the university, and they conduct their own prior art search. They draft their patent application, and then they file the patent application. So I would say that if you are not very familiar with the patent language and how to write and draft a patent, this is a recipe for disaster, I would say, because to have a patent filed, anyone can file a patent, and then you will just like put it on your wall and say, oh, I have a patent. But then if you don't have a granted patent, or if you don't have a patent that has a commercial potential, it doesn't mean much. So I would say that in most cases that we have encountered, the patent is not written according to the Brazilian PTO language. It does not meet formal requirements. It does not actually cover what the applicant thinks it covers. And at the end of the day, patent is not granted. The same happens in trademarks, and even more often in trademarks. So the trademark system has its own specificities and details that count a lot at the end of the day. So budget is always a problem, and we have already seen startups filing their trademark applications and then coming to us due to an opposition filed by a third party or a decision by the Brazilian PTO denying the application, or then suddenly they have a non-use cancellation action filed by a third party because the client didn't know that he had to use the trademark as it was filed, as it was granted.
Mm-hmm.
So I think that, and of course, I mean, then we have to work again on the case and do it all over again. And yes, it was a waste of time and money in the beginning, and they should have come to us, or at least looked for professional help at the beginning. So I would say that the root cause of such problems, especially in Brazil, I would say, is the lack of IP knowledge and IP awareness. So IP is not yet a priority for some companies and entrepreneurs. So first, we need to educate and foster this IP knowledge and this IP generation culture. And it is only when you understand the system that you can use it more and better. And at Venturini IP, we do a lot of workshops and participate in IP mentoring programs to really try to contribute to disseminate this IP knowledge.
Yes, yes, I totally agree with you that we also have had many cases when an applicant just came and said, like, I want to patent a trademark or something like that. A lot of people do not know anything about IP, trademarks, patents, designs. So I totally agree that we should educate people, and because IP, intellectual property, is a way for earning some and to increase the revenue of company, because you could also sell some IP, you could sell your company as a startup. So there are a lot of ways what to do with IP. And last but not least, as an expert in IP strategy, what recommendations would you give to startups regarding their IP?
Yeah, so speaking about startups, so we do work with some startups here in Brazil, but I would say that to better understand when, how, and where to start with IP, I think one should keep in mind, I will try to summarize it in 4 key points in order to use more and better the IP system. So first of all is a startup, for example, should assess the level of maturity of IP of the partners of the company itself. So it's really asking yourself questions such as, what is IP? What are the advantages of using it? Would IP bring additional tax incentive? Does the company has an IP portfolio? Does the company is willing to create one? Do we want to protect? Do we want to keep as a trade secret? What kind of strategy are we looking for? And is our IP strategy, or we want to, the fact that we want to protect our inventions to file the trademark, is it in line with our business model, with our business objectives? So yeah, I think questions like that. And the results of the company's creative process, will it be protected by IP? Will IP agreements be celebrated? So different type of questions that one should ask the startup in order to assess if there is an understanding of what is IP or not. Then the second point I would say is to understand the IP system and the advantage of using it. As you mentioned, I mean, it's important to educate, to disseminate this IP knowledge, because there are several advantages when you use IP. So the first one, and for example, using the example of patents, so you have this market positioning, so obtaining freedom to operate or mitigate infringement risks or protect your IP. You will have an exclusivity in the IP exploration, commercialization. This also helps in terms of negotiation, because, I mean, you will have this exclusivity. Diversification of R&D risks also, it's quite important. So to attract investors, to increase the value of the company, access additional tax incentives, for example. So those are some examples of advantages that should be known in order to better understand the system and to understand the value of the system of using this IP tool. And using IP tools throughout the entire R&D life cycle. This is the third point I wanted to mention. It's not only a question of protecting your trademark, protecting your patents, filing trademarks in Brazil or abroad, but it's also a question of at the beginning of your R&D, for example, even before you have created something, you can conduct patent landscapes in order to understand the evolution of a specific technology, in order to orient the lines of research to a result that is distant from the state of the art. And this will save time and money instead of waiting to have created something and then, okay, now I want to protect, I will conduct a prior art search and, I can see that I don't have novelty, I don't have inventive step, so I don't deserve a patent. So I invested money and time in a project, in a research project that's at the end, the result cannot be protected. So it's really trying to use these IP tools not only as a tool to protect, but also a tool to help you to have better decisions business-wise, I would say. It's important also to, for example, use NDAs, non-disclosure agreement, confidentiality agreements. It's important to have in mind not to reveal what you have discovered. Pay attention when you publish an academic paper, for example, a scientific paper, because in Brazil, for example, we have this grace period for patents. So once you publish something, you have 12 months to file a patent application. So this is the grace period. So it's important to keep your information as secret as possible. And also, for example, like using IP valuations, conducting IP valuations for licensing purposes. This is something that can be done. Sometimes it's a hypothetical exercise that can be done even if you don't have a patent, but at least you will have the feeling or the sense of how much it values and how much you could potentially obtain as a return on investment if you protect. So those are different ways of using IP in order to really help startups, business leaders, entrepreneurs, to really help them in their day-to-day management decision, I would say. And the last point is to really, if possible, structure an efficient IP operating model, or at least understand at what point one should start thinking about IP throughout, for example, the R&D life cycle, or throughout the process of creating a new brand when we talk about trademark. So, and this will really help to understand, if you take your R&D process, you can then really understand at what stage should I start thinking about IP. The same for the creation of a brand. At what point should I start thinking about trademark? Should I conduct a prior art search to see if the trademark that I want to register is available or not? Because if it's not available, I maybe will have to change the name of the brand, change my branding strategy. So, and this has a huge impact to the business of the company. So, and it's really trying to understand if my current IP portfolio or the IP portfolio that I want to generate is in line or will be in line with the business strategy, the business objectives, and the core values of the company. So I would say that these are the main takeaways that should help any startup to have a clear vision of what to do with their business in terms of IP. And at Venturini IP, we can definitely help startups in this sense also.
Yes, great recommendations. I totally agree. I like the points that the startups or anyone should consider IP in initial steps, not when you just understand that you need to file. You need firstly understand what to file, how to file, is it necessary or not, when it will be necessary, etc. Thank you, Luis, very much for your time. It was a pleasure to meet you and to discuss these points with you. Thank you.
Thank you very much, and it was a pleasure.